Everyone. It is Thursday, March 13th, 2025, and I call this meeting of the Senate Elections Committee to order. And we do have a quorum. And we have two items on the agenda today, a Westlin bill and a Koran bill. The first one we're going to look at is Senate File 2384, Senator Westlin, which is the Secretary of State's Election Administration Bill, and it will be forwarded to Judiciary. Senator Westlin, I believe you have an A4 author's amendment?
Yes.
And so we should move that amendment. Since it's an author's amendment, it's just a simple majority. All those in favor say aye.
Aye.
All opposed, nay. The amendment is adopted. And Senator Westlin, please continue with your bill 2384.
Thank you, Mr. Chair and members. It is my pleasure to once again carry the Secretary of State's Office's administrative bill, and that is represented in Senate File 2384 as we have just amended it. This bill does include provisions to improve the way that our elections function for voters across race and place, and it's brought forward by voters and local election administrators. I believe that we are going to have Ms. Stengel do a walkthrough of the bill, a section-by-section walkthrough, and then I do have one testifier at this time, Ms. Freeman, who is here from the Secretary of State's office.
Council Stengel, are you ready to walk through the bill?
Yes, thank you, Mr. Chair and members. I'll walk through the bill as it's amended by the A4 amendment, going sort of back and forth between the two. So the first section has to do with election day registration, and it strikes the requirement. This has to do with, the changes are on page 2, and it has to do with providing proof of registration by employees of residential facilities. You'll see on lines 21 through 24, it strikes the requirement that these facilities provide a list of names of the employees that work there, and instead on lines 2.3 to 2.4 requires the employees to provide proof that they are employed there before they vouch. Section 2 requires that additional proofs of residency for students be allowed to be used during the 18 days before an election and on election day. Section 3 on page 4 strikes a requirement that the voter registration application include a box to indicate their preference to join the permanent absentee voter list. And this is replaced by language in section 4 that you'll see on page 7 that requires an application to include a place to apply to automatically receive a ballot under subdivision 5, which is the to automatically receive the absentee ballot. Section 6 and 7 update terminology relating to absentee ballot envelopes to make sure that they're properly identified as the right kind of envelope. Section 8 refers to temporary locations for absentee voting and allows federally recognized Indian tribes that have off-reservation tribal lands to request a temporary polling place on those off-reservation tribal lands following the process that's already in current law. Section 9 amends the handling of absentee ballot signature envelopes. And if you look on page 10, there's a series of new language here that talks about counting and cross-checking the handling of envelopes and accounting for any discrepancies in the number of envelopes versus ballots, and noting any of those in the ballot board incident log. It also requires that all absentee ballot envelopes be retained for the duration of the contest period. Section 10 makes some changes to talk about referring to the number of absentee ballots from the tally that are inserted into the ballot box instead of the number of voters. Section 11 has to do with, let me back up. There's a new section 11 in the A4 that just strikes an obsolete reference to a report date. Section 11 in the bill, which is on page 11, and I'll note that there's duplicate and weird numbering that's happening going back and forth between the bill and the amendment, and that'll get fixed in the next engrossment, so I apologize for this sort of weird and confusing numbering. So section 11 in the bill itself requires early voting officials to take certain actions related to removing, securing, and documenting ballots each day during early voting. And this provision doesn't become effective until early voting certification happens. Section 12 on the next page has to do with changes to judicial offices, county candidates for county attorney and county sheriff. It specifies that these candidates are not required to include their address of residence on affidavits of candidacy, but they must now include a phone number and email address, and specifies that if they use a bill as proof of residence, that all candidates that do this, the bill must be recent, and it specifies what recent means. Section 14, I'm going out of order a little bit because it's in statutory orders. Section 14 in the A4 amendment specifies that this section, as opposed to, it talks about the whole section applying, not applying to candidates for presidential electors. It's a clarification as opposed to the subdivision not applying. It requires each nominated candidate to submit a petition, a signed notarized affidavit of candidacy for president or vice president that includes specified information, and a declaration that the candidate will follow all applicable election and campaign finance laws. Going back to the bill itself, on section 13, on page 13, requires a candidate who is absent from the state or precinct during the filing period to provide proof of residency when they submit that candidacy, affidavit of candidacy, and if they submit that copy of proof of residence, that's private data. The same thing in section 14 specifies that for all candidates that mail proof of residency, classifies that data as private. Section 15 on page 15, on page 14 has to do with when municipal boundary adjustments take effect. And it says that if a municipal boundary adjustment is effective more than 46 days before an election, it applies during that election. But if it takes effect closer to the election than that, it will wait until after the election to take effect. In other words, that change won't take effect during the absentee voting period. Section 16 on page 15 is a whole new section on chain of custody plans. This requires a county auditor to develop, a chain of custody plan to be used in all state, county, and municipal school districts that relates to, sorry, I lost my train of thought, that will account for physical and cybersecurity of election-related materials. This has to be filed with the Secretary of State's office. A municipal, school, or special district clerk is required to use the county plan or to come up with their own plan. And these must be reviewed prior to every election. And the initial plan must be filed by counties, must be filed by September 1st of this year. Section 17 has to do with political party appointments. And you'll see that these sections 17 and 18 have been deleted out of the bill and reinserted as sections 19 and 20 in the A4 amendment, and provides details on how how the process will work. The list now must include specified information, including an indication that the people on the list have indicated a willingness to serve as election judges in the last 2 years, and must include contact information. If the required information is not on the list provided by the parties to the Secretary of State does not forward that information to the appointing authorities. The timeline for the list is moved up by 1 month to allow for additional time for the process to be completed. In section 18, there's a process for exhausting the voter list, and it specifies what that means, how members are contacted, and how individuals are contacted from that list, and what it means to exhaust that list. and appointing authorities are required to exhaust the list from political parties before appointing judges from additional sources. Section 19 adds a statement to, and you'll find that on page 18, adds a statement to the election judge oath of office that says the election judge won't share information about voting that they know to be materially false. They won't hinder, interfere with, or prevent a person from voting, registering to vote, or aiding another person in casting a ballot or registering to vote. Section 20 removes an exception that allows untrained election judges to serve in precincts where less than 100 individuals voted in the last state general election. Moving back to the A4 amendment, there's a new section. It'll be section 23. This is a section about the election reporting system. This requires the Secretary of State to maintain an election reporting system that will facilitate the collection, aggregation, and reporting and sharing of unofficial election results to the public. It assigns responsibilities and timelines for entering candidates into the system. It requires testing prior to the election, and requires the county auditor to report unofficial election results, and this applies for state and federal elections. Also, it makes it clear that the results in the system are unofficial, and the results aren't official until the canvassing board certifies the election. Going back to the bill itself, section 21 makes some changes to the errors and omissions process. You'll see those changes at the bottom of page 19. It allows for service by email. It allows a process for all parties to agree to correct an error, omission, or wrongful act without a court order if everybody agrees. It allows for the prevailing party to get attorneys and disbursements from the party who did not prevail in certain circumstances. And then it allows election officials to correct ballots that do not conform to the ballot's formatting standards without a court order. Section 22 requires jurisdictions that conduct election by mail to send ballots no later than 28 days before the election, rather than the 14 days under current law. Section 23 amends the Voters' Bill of Rights to remove a reference that prohibits a candidate from assisting voters, and this is consistent with a consent decree from a few years ago that struck down, or that invalidated a law about candidates assisting voters. Section 24 strikes a requirement that election judges initial the backside of ballots. Section 25 on page 23 has to do with polling place rosters. It adds a reference to the location of residence instead of just the address on the polling place roster statement. Section 26 lengthens the timeline of a city canvassing board from the 8th day after the election to the 14th day. And it also requires the city or town canvassing board to declare the candidate duly elected who received the highest number of votes. Section 27 does something similar, only it's for school boards. Section 28, sorry, I lost track of the page number here, that's on page 25, provides that if a municipality conducts a special election by mail, the school board may designate a polling place not used by the municipality for their polling place. Section 29 on the next page, at the top of page 26, strikes obsolete references to separate ballots and separate ballot boxes. It's just not a practice that's done anymore. On page 27, section 30, changes the timeline for calling a special county election. The election may be held within 84 days after a resolution instead of 74 days under current law. Section 31 requires the election of municipal officers to be held after incorporation or consolidation to be held on one of the uniform election dates, and requires candidates to file affidavits of candidacy in the same manner as other municipal candidates. Section 32 on page 28 provides hospital districts must act as a canvassing board between the 8th and 14th day after an election, canvass the returns, and declare the candidate duly elected who has the highest number of votes. Section 33 on page 29 transfers the remaining balance of the voter equipment grant account into the Voter Operations Technology and Elections Resources account, or the voter account. This is effective the day following final enactment, and that's because the voting equipment grant account is repealed in the next section. And finally, the repealer, you'll see in the A4 amendment, is deleted and reinserted, and that's because an additional section is repealed, and that's how the system works. You delete the whole thing and you reinsert it because that's how an archaic system works. The three sections that are repealed is 206.57 subdivision B. That's a township voting equipment study that was completed several years ago. 206.95, which is the voting equipment grant account. And 209.06, which is inspection of ballots.
Thank you, Council Stengel. Senator Westlin. I'm sorry, Senator Westlin.
Thank you, Mr. Chair. I do have Ms. Freeman here from the Secretary of State's office, and also Michael Stahlberger is here from the Minnesota Association of County Officers on Zoom, as I understand it, and is available to answer questions.
And who would you like to?
Ms. Freeman
Senator
is here
Westlin,
to.
I'm sorry.
Ms. Michael?
Ms. Freeman.
Okay, I'm sorry. Mr. Stahlberger can go.
I just meant he's going to testify,
Okay.
but he can go after me. Yeah, sorry.
Okay, sorry. Never mind. Ms. Freeman would like to go.
Ms.
next.
Freeman, please identify yourself for the record and continue with your testimony.
Thank you, Mr. Chair. My name is Nicole Freeman, the Office of the Secretary of State. So thank you to Senator Westlin for bringing this bill. The bill, as she mentioned, seeks to make technical as well as small policy changes to election provisions that were both passed recently, as well as some that were passed not so recently, based on the experiences of voters and election administrators in recent elections. So we really appreciate the collaboration and input from our local election partners in MACO, AMC, LMC, the Township Association, as well as individual jurisdictions. And we know there's a few places in the bill that we'll be continuing to work with them on, and we look forward to doing that. So one provision that does come from, or a couple provisions that come from local feedback, just to give a few examples since the bill is larger. Section 5 is one such example that came from local feedback. This provision adds flexibility to how local municipalities administer in-person absentee voting. So if a jurisdiction chooses or is designated to administer absentee voting in person, it allows the municipality to be designated either for the full 46 days, which is the current requirement, but inserts new flexibility to allow them to just be open for the early voting period, which is 18 days before Election Day. So we hope with that flexibility that jurisdictions will be able to work through any staffing challenges and things like that, while also preserving access to voters during the time where we know that voting in person and ahead of Election days really ramps up during those last 18 days. Another example of a provision that's come from local feedback are the changes that are made towards the end of the bill in sections, so as amended, sections 29, 30, and 35. In the bill, they're 26, 27, and 32. These are sections that relate to adjusting the canvassing dates for municipalities, school districts, and hospital districts. And so what we heard from folks is that they would like an extension. So in the original bill language, we shifted them all the way back. We heard back from additional folks, and having that full 3 days and then adding on up to 14 days to conduct their canvassing board meetings for all elections would be really helpful. The hope and the goal for municipalities and these other jurisdictions is to be able to hold their canvassing date on the same day as they have a normal board meeting, so they're not calling folks in on a special meeting. But it also provides flexibility so that they can schedule their meeting at a time when the county, or at a time after the county has their official results ready and their abstracts prepared for them to do the canvass. So we're looking forward to being able to make that adjustment as well. A few provisions that relate to recent law changes are the adjustments made in sections 3 and 4 that relate to the permanent absentee list. Again, we heard feedback from counties as they administered this for the first time in the 2024 primary and general elections, and heard that a better place for this would be on the permanent absentee ballot application rather than the voter registration application. The absentee ballot application allows local jurisdictions to capture both ID numbers potentially, if an individual has them on that application, and then allows hopefully an ease for ballots to be accepted and or not, at least not rejected, for the purpose of not having that second number that they might have failed to include. Another example of a recent change that we're making a slight modification to is Section 8. And that clarifies off-reservation tribal lands could serve as a temporary location for a tribal voting location. And we feel like this is a necessary adjustment, and I think a minor adjustment, because what we have since learned is that a number of tribal community centers and other spots that would be really great temporary absentee locations, they are located on off-reservation tribal lands. And so we know that there's additional significant off-reservation tribal land in neighboring counties surrounding a reservation. And so we wanted to be able to incorporate those voters and access for those voters as well. An example of how this worked on sort of a voluntary basis, Pine and Aiken counties, they held locations in 2024, despite the fact that there's no technical reservation land for the Mille Lacs Band of Ojibwe in their, that overlaps with their county. And so, I think we're sort of looking to that model to make it official that those off-reservation tribal locations could be considered for absentee voting. A few examples of the older statutes that we're making updates to. As Ms. Stengel referenced, we're making a number of them in section 29 of the bill language, 32 as amended. We're updating there how townships in Cass, Itasca, and St. Louis County can be dissolved, and not so much updating the process, but updating and removing some of the requirements that are no longer necessary, like separate paper ballots, a separate ballot box, and just modernizing things to how we currently conduct elections. Another example of something that we are updating in order to serve voters better is section 22, as amended, section 25. And this relates to, I think, largely the sort of shift in mail delivery times that has been happening over the last several election cycles. And so this is an adjustment to require that jurisdictions who vote solely by mail, that they must send out those ballots at least 28 days in advance. So that gives then the 4 weeks of time for ballots to be transmitted to the voter, as well as transmitted back to the county location. A couple of notes, and then I will be done and happy to answer questions. Just a couple of notes on the author's amendment for a few things that were new there, new provisions to that author's amendment. One such provision is a requirement for minor party candidates just for president and vice president, that they also need to submit an affidavit of candidacy in addition to the current petition requirements. And the reason for that is that there's not currently anything requiring a candidate to swear to their eligibility. And additionally, there's nothing to require or there's nothing to prevent, a group of folks submitting a petition on a candidate's behalf without their consent. And so we're hoping to get that candidate affidavit from the individuals who are filing. A handful of other states have a similar requirement, and so we think that will just allow some confirmation that they understand the eligibility requirements to serve in those offices, as well as ensuring that someone's not filing something on another's behalf without their consent. And then finally, as McStingle noted and went through, as we were working on the author's amendment, we knew that we wanted to add a requirement for counties to report unofficial results through the election night reporting system, or ERS, for all state and federal elections. So currently, all 87 counties, they do use ERS to report those unofficial results for statewide elections, and they often use the system too for other elections that happen throughout the year. However, there's nowhere in statute that requires them to do so. And then in working with Senate Council, we also discovered that there actually isn't a requirement in statute for the OSS to maintain such an election night reporting system at all either. And so we worked together to codify adding in the requirement for our office to maintain that system, as well as including some requirements around candidate filings, because that system currently supports the publicly accessible list of candidate filings. And then the other requirement that is related to that system is requiring counties, this is currently something that we walk counties through and request them to do, but this would be requiring counties to conduct a results reporting test at least 7 days prior to Election Day, just to make sure that things are working on both ends for those unofficial results that will come up on Election Day. With that, I will turn it over to Mr. Stahlberger with your permission, Mr. Chair, and happy to continue the conversation about the bill. Thanks.
Thank you, Ms. Freeman. I think Mr. Stahlberger is on Zoom. Mr. Stahlberger, if you can hear us and identify yourself and continue with your testimony.
Yeah, thank you, Chair Carlson. My name is Michael Stolberger. I'm Director of Property and Environmental Resources for Blue Earth County. Our department administers elections for about 40,000 registered voters. And today I'm appearing virtually on behalf of the Minnesota Association of County Officials, MACO. I appreciate the opportunity to testify remotely. I would prefer to be there in person. I just had a scheduling conflict that I could not work myself out of. But anyways, MACO would like to express our support for many of the provisions in Senate File 2384. Ms. Stengel and Ms. Freeman have walked through many of those provisions, but I will just draw attention to the ones that we have very strong support for, and then I'll also bring up some of the provisions that we do want to continue the conversation with the Secretary's office and with the bill's authors on. First off, for the provisions that MACO strongly supports, we strongly support removing the requirement to have the permanent absentee ballot application process be able to be requested as part of the voter registration application. That resulted in oftentimes voters not understanding what box they were checking and resulting in a lot of rework and extra work for county elections and city elections administrators. And so that's a very welcome change on behalf of administrators across the state. We also strongly support a more effective process for appointing party-affiliated election judges. Our goal is always to exhaust those lists and place those judges who wish to work in our elections in polling places and on the ballot board. And so the new process, being more robust and more detailed, will help us make sure we exhaust those lists. Finally, another section that we strongly support was the section that creates a process for counties, candidates, and other individuals to correct their ballot issues in a more timely and efficient manner. We pride ourselves as election administrators to make sure those ballots are perfect. We have no alternatives there. And so when we do identify issues, the sooner we can correct them, the less impactful those changes are on candidates and on voters. And so that's a very welcome change for us. As I mentioned, there are some provisions that MACO conditionally supports. We conditionally support them just because we know continued conversations need to occur, and we fully expect those conversations to occur. We've been able to work through many of our concerns and provide some insight thus far, and will continue to do so. But some of those areas that we do want to continue to work on, the section that allows the student housing list to be used for college students during the early voting process is workable. We just need to make sure sure we get those lists timely so that they can be validated and reviewed before they're used in the voting process. We also would like to continue the conversation on exactly how a permanent absentee ballot can be requested. Removing it from the voter registration application, as I mentioned, is already a great step in the right direction. We would like to continue the conversation as to how it is available on a regular absentee ballot application to ensure that we're collecting all the information we need and that the voter understands exactly what they're requesting when they fill out that request. Our preference would be to have that be a separate or standalone document or application, but we look forward to continuing that conversation. Also, it's already been mentioned that there are some changes to allow cities or towns to administer the entire voting process for prior to election day or just the 18 days of early voting. We think that is a change that will allow some variability and flexibility for cities and towns, and so we support that, but we want to make sure that we fully understand the expectations of the processes outside of that 18-day window when cities or towns elect to do that. Another provision that we will continue to work is related to the new sections in law of processing, opening, and reconciling absentee ballots as part of the ballot board. A lot of what's listed in that section or in those sections are tasks and items that are already being done by our ballot boards, our cities and our counties. However, putting them in law is something that we support. We would like to just make sure that we can acknowledge the processes are going to be slightly different for each of our cities and towns, and so the framework there is really going to get us with a good starting point. I'll also point out that those provisions, as they're amended, are going to provide some really good clarity on the counting process for our ballot boards, so we can ensure that when a valid ballot is received through the absentee voting process and that voter receives credit for that ballot, we are counting that ballot for that individual. We have those checks and balances built into these sections, and that will be very helpful for the chain of custody and overall backup and security provisions of absentee balloting. A couple other provisions I'll just point out that we want to continue working through. Chain of custody plans, that new provision provided in this bill, again, very welcome as a way to provide a starting point for cities, towns, counties to actually have an established process. Many counties already do this, but having it documented is another layer of transparency that will be well received, and we appreciate that. We do want to acknowledge the extra workload, and so we look forward to partnering with the Secretary's office on having templates, having assistance from them to make sure that we can have consistent and meaningful chain of custody plans. Lastly, the changing of the canvas dates for our cities, our towns, our school districts, and our hospital districts. We fully recognize the need to have a variety of dates there between the 3rd and beyond dates for cities and towns and whatnot to canvass their results. We would just like to continue the conversation to make sure that there's clarity and expectations on when counties will have to provide that list as to whether or not it must be at the earliest day available or if it's through a mutual agreement with that local city or town. In closing, MACO always appreciates being involved in conversations regarding proposals that are related to elections law. We want to make sure they can be implemented by all counties across the state, and we really look forward to continue working with the author, Senator Westlin, and the Secretary's office on this bill. We will continue to generally support the bill. We recognize it as additional opportunities to update our administrative processes and other technical inefficiencies in law, and so we look forward to that continued productive work. I'll conclude my testimony, but I'm always available for questions if there'd be any directly related to some of the administration or applicability of the provisions. Thank you.
Thank you, Mr. Stahlberger. Next, we have Ms. Julie.
No, we're done.
I'm sorry.
We're done with the testimony. Is there any discussion?
Okay, that's right. We're on.
Any discussion?
Is there any discussion by the members? Senator Lucero.
Thank you, Mr. Chair. This question is probably for staff. On page 12, line 27, there is, the line begins, if an original bill. My question is there a definition for original bill? And what I was attempting to look up here is at the beginning of the chapter, and I'm seeing a reference that all definitions in chapter 200 apply to this section, which is chapter 204B. So I went to chapter 200 and I just scrolled through the terms there, and I did not see a definition for original bill listed there. So my question, Mr. Chair, and to staff is original bill defined anywhere, perhaps somewhere other than chapter 200?
Ms. Stengel.
Mr. Chair and Senator Lucero, I can take a stab at it, and if not, Ms. Freeman can bat cleanup. So I think the answer is, it is in the previous line there, proof of residence is authorized for Election Day registration in 201061. There's a list there of things you can use for residence, and I think that's where you would find what an original bill is. And Ms. Freeman might have some more detail on what an original bill is and how you identify that.
Ms. Freeman, any comment?
Thank you, Senator Carlson, Senator Lucero. So I cannot remember off the top of my head if there's a full definition in 201.061, but I do know that there's also additional proofs of residency listed in state rule, and so can look up there. In rule, it discusses which types of bill, for example, a phone bill, a mortgage statement, things like that, that can be used. And so that is what it is. It's sort of referencing the language that's in 201 as well as what is in rule to clarify. This question came up as election administrators were first using this new provision that was just passed in 2024 as candidates were filing earlier this year. And so the question came up that in rule, it states that the original bill, the due date needs to be within 30 days before or after Election Day. And so that doesn't really work when you're filing in May or August, right? And so we wanted to clarify that the bill, like the important part there is the bill is recent, right? You live where, as proof of residence, you live there, you have a recent bill that reflects that, as opposed to, showing a bill from 2 years ago or something like that. So that was the attempt there, is to use the same terminology that's used in other places in statute and rule to clarify what would be required there.
So, Senate Council has a little bit additional information from the rule.
Thank you, Mr. Chair, and Ms. Freeman, thank you for the time on that. I found the rule that Ms. Freeman was referencing for additional proofs of residence allowed. It says, as much as she described an original bill, including original statements and start of service notifications for telephone, television, internet provider service, regardless of how those telephone, television, or internet provider services are delivered, gas, electric, solid waste, water, sewer service, credit card or banking services, rent or mortgage payment. And then it goes on to talk about the 30-day period that Ms. Freeman talked about. For bills delivered electronically, original means a printed copy of the electric bill or a display of the bill on the voter's portable electronic device.
Senator Lucero, follow-up.
Thank you, Mr. Chair. Okay, so here's where, and I sincerely appreciate that, and here's where I'm getting at. I'm not going to do anything with this now, but I was not here to hear the original motion. If this is being laid over, it's moving on somewhere. But at some subsequent step, the concern that I've had for many, many years is when it comes to presenting a utility bill of some kind, and we just heard the list, with as evidence or proof of residency, in our current day and age right now, I can manufacture any utility bill in 60 seconds, especially when I just heard digital, in case the bill is digital. So one of the things that we've been working on, in myself, Senator Mayquade, and others, is deep fakes. We know the technology exists out there to artificially present people manufacturing pictures, videos of situations that completely are fabricated. That technology exists today, and it's much more advanced than producing a Word document or a PDF and printing that out and bringing that. So I can take my friend's utility bill from across town And I can get that in an editable PDF form or a Word document form or whatever, and it can be edited. My concern is, and it's not for today, I'm just airing this now, I'm very concerned about authenticity and what measures we might be able to take to, whether it be a watermark, again, I don't know, I want to brainstorm this, but it's just something I think this committee should take into consideration as we are considering deep fakes and other digital alterations in other contexts. So thank you, Mr. Chair.
Thank you, Senator Lucero. And Senator Port, did you have a related comment?
Yes, thank you, Mr. Chair. I agree with you, Senator Lucero, that there are definitely issues around technology and deepfakes that are concerning and that we need to address. But I think in this case, like Microsoft Word has existed for a really, really long time. And you would be able to make something like a utility bill for decades now and print it out. Ms. Freeman, is there any evidence that that you all have found in the past 20 years that people are submitting fake utility bills in order to vote, to be able to vote?
Mr. Chair, just to level set here too, though, this is the
Senator
affidavit of
Westlin.
candidacy. This is not about voters. This is about somebody, a candidate who's filing for candidacy, and this is what they are providing to prove that they're eligible or reside in the district. But I will let Ms. Freeman follow up.
Ms. Freeman.
Thank you, Mr. Chair and Senator Port. So no, I'm not aware of any prosecution that has happened, related to someone submitting a false document like you described for registering to vote. Yeah.
Mr. Chair, if I may.
Senator Port.
I think there is a fine line between having systems that have safeguards around them, making sure that folks who are filling out candidacy paperwork are who they say they are, and that voters are who they say they are. But there's also putting in too many barriers and making that, now a requirement that someone can't meet. So I think the work you've done here makes sense to me, and I hope we move forward with it as is.
Senator Lucero.
Thank you, Mr. Chair. And that line of questioning actually just raised another question. So in the question was to the effect of, are we aware of any prosecutions or something to that effect? When somebody brings in a utility bill as evidence of residency, for whatever context, in this context, affidavit of candidacy, or in the context of voter registration, is that retained by the election judge, or is it just presented and then is it retained by the voter or candidate?
Ms. Freeman.
Thank you, Senator Carlson, Mr. Chair and Senator Lucero. No, a copy of it is not retained by any of the folks, whether it's during election day registration or candidate filing. I think I will say, though, both with election day registration as well as candidate filing, if someone is using an original bill, they're also required to produce some form of ID. And by some form is defined in that 201.061, what forms are valid. And so there are sort of additional pieces of information that are provided as well. And I think the important thing, too, in this is that I think to Senator Port's sort of loop to what Senator Port was asking about, the individual, whether they're filing for an affidavit of candidacy or registering to vote, they're swearing and affirming that the information that they're presenting is true and correct. And so, if there was further investigation into items, like the sort of just basic perjury on top of other voting violations or other violations would come into play. So, yeah.
Senator Lucero.
Thank you, Mr. Chair. Thank you, Mr. Chair. And I appreciate that. And we do know that the case of perjury was just cited. We do know that there are all manner of additional contexts where people swear to be telling the truth, whether they be in the court of law, under the penalty of perjury, or whether they be in many others, but people still lie. People still fabricate information, and we know that happens. And again, I'm not looking to do anything here. There's no oral amendment or anything. I'm just want to put it under the radar of this committee that specializes in elections, that it has long been my contention in my time in office that the law is not keeping up with technology. And that's across the board in many different areas. In this area, we have a law, and I don't know how old it is, multiple decades I'm guessing, where one can present a utility bill as evidence of residency, but with the advance of technology and being able to fabricate a complete, very genuine looking utility bill, 30 to 60 seconds, print that out, bring it in, and the fact that it isn't retained, so it's just simply shown and then taken back, it'd be very challenging to prosecute that because the artifact of evidence wouldn't be there anymore. It'd be kept by the person who had registered to vote, or in this case, candidacy. So anyway, just something on the radar, something I think we should think about, perhaps a future conversation if this bill is further considered in an omnibus bill or maybe on the floor. So thank you again, Mr. Chair.
Thank you, Senator Lucero. Any other questions? Senator Cran, did you have a question?
Thank you, Mr. Chair. Yeah, and I think Senator Port and Lucero, I had the same area or same question. I think we got to do one of two things. Either create a process that you actually verified as Secretary of State that it's a legitimate address, even the utility bill. You can do that today. There's all sorts of data. We can validate where you hold all your assets, where your utility bills are in real time. That's all available through the data aggregators. Either we do that, or we then have to go and have consequences of lying. That self-attestation sounds good, but we just saw maybe if you bring a lawsuit, maybe if you have enough evidence and you incur a pile of costs in order to do that, you may get it overturned. At the end of the day, that's a crapshoot. Or we put forth and we have consequences for either party where we police ourselves and the candidates we put up, that if we're willing to risk losing that seat because they could be disqualified in an election, as we just saw. And I say that coming from in my election as Representative Bob Barrett was kicked off the ballot in August. And so parties would be self-policing like everything we do in campaign finance. It's a good process because we all scrutinize each other's records and activities and everything. So either Secretary of State, we have to figure out how you actually verify the data. Self-attestation isn't good enough. And I think we can have a high bar for a candidacy. That's not that complicated. So we can do that. So we have to do one of those two. And so I think we have to continue to work on that. And so, Ms. Freeman, I do have a couple questions, though. On the chain of custody, I think we've seen a variety of issues, certainly in this last election. And I think a plan is good, but it still doesn't require it be executed, nor does it require anybody to have any oversight into it, except for those that are explicitly called out that either are election judges on end of election season day and or ballot boards that start prior to end of election season day. And so we don't have those things. So I think we need to look forward or look in addition to that plan. I think there's a couple bills out there that we have to enhance what was a poll challenger, which really has a little meaning today because half the ballots are in by the end of election season day. And so we have minimal oversight or the opportunity, especially localized election in person. But we don't have any of that for every ballot comes in after that. So I think we've got a couple, and we've talked about it, to look at what is that poll challenger, not poll challenger, sorry, a poll observer, and so those critical areas that we have oversight, both equally partisan in those areas. And so I think we need to keep looking, and how do we blend that in so it's practical, but provides that transparency and accountability that we expect. So I don't think there's an action plan, I think, or a question, but I think we have to figure that out because it's really important. We had the crazy vehicle in Edina where we don't have any chain of custody, or even if we have chain of custody, there's no oversight in that. And we require that for end of election season day transport of ballots, but we don't require it in any of the 46 days prior to that or 45 days prior to it. So I would like to continue to work on that because I think there's room. We definitely have to do that because there has to be some opportunity for transparency and oversight. So, and then the other one on section on the A4 amendment, section 20, as it relates to likely because of the lawsuit in Hennepin County that the clarity on exhausting the party lists on both sides. Is the requirement, it appears that requirement to reside in the political jurisdiction in order to be a ballot board member or an election judge seems to be very restrictive. And so is that a new requirement? Ms. Freeman?
Thank you,
Ms. Freeman.
Thank you, Mr. Chair, and Senator Koran. So I'm just going to that section. So my recollection of it is that it's not that the individual is, for these lists, not for the general appointment, but for these for the lists, it is required and has historically been required that the appointing jurisdiction reach out to individuals from these party lists who reside within the jurisdiction. So if the county is hiring for their county ballot board, they would reach out to everybody in, X county. If an individual city is hiring for a ballot board or hiring on election day, then they would reach out to the folks in their city. Understanding too that there are folks who may have said that they would be willing to travel outside of their district, but I think the primary, the overwhelming majority of folks are folks who are interested in serving within their, county at least.
Mr. Chair?
So.
Senator Koran.
Thanks, Ms. Freeman. And so it looks like it prohibits that, as the language is today, from somebody outside of that political jurisdiction, if we don't have the ability to meet that capacity or the need within the large cities, that we could have somebody from outside the jurisdiction on that list. So would it prohibit somebody because it has been a common practice. Others have been election judges in many different districts, Hennepin County, and from coming outside of the district. And so does that prohibit somebody from coming outside of the district of Hennepin County from serving as an election judge or ballot board?
Ms. Freeman.
Thank you, Mr. Chair and Senator Koran. No, I don't believe that it prohibits an appointing authority from hiring someone who may appear on this list who is outside of the jurisdiction. I think what we attempted to clarify is what is sort of how does a jurisdiction exhaust the list? And so it wouldn't prohibit them from using someone that appears on the list who resides in another jurisdiction, but sort of functionally how are jurisdictions reaching out to these folks and trying to schedule them, right? And so if there was, I think to your point, if someone reached out to the county and said, hey, I live, in the neighboring county and I'm willing to serve on this and I appear on this list, I don't believe, I'm happy to look more closely at where you think it might be prohibiting them from hiring that. I think that it doesn't require a jurisdiction to look outside of their own, beyond the list that's provided to them. And I think that's also a piece of it, right, is that our office wouldn't be opposed to providing additional, I think it's possible to provide, additional information or names of other people if a county would ask us. I think historically, we've sent a number of counties to back to the parties when they may have trouble, finding election judges of certain political affiliation. And so I think we could continue that same practice of referring folks back to the parties. Yeah.
Mr. Chair and Senator, I think just looking at the language that was not amended, the original language in this section of statute at line 16.3, and Ms. Freeman can confirm whether I'm reading this correctly, but it says that the list that the party provides has to indicate which voters are willing to travel outside their precinct. So it seems to me it's assumed that that is a possibility.
Mr. Chair. Thank you, Senator Westlin. Thank you, Ms. Freeman. I appreciate it. We'll continue to make sure that we're all on the same page. So yeah, as long as we have that, and both sides, right? Both. We need just as many judges on the other side. So,
Yep.
I think the only other one I have, Section 24 removes election judge must initial backs of ballots. So now you just have to initial the front of them. And so are stamps allowed, or do they have to be wet signatures?
Ms. Freeman.
Thanks, Mr. Chair and Senator Koran. So the intent here was just to update. This law hasn't been changed since 1981, when we had, several colors of paper ballots, several ballots and all of different colors, right? And so, and there was only printing on the front of those ballots, and so initialing on the back made the most sense. Right now, I think that it's, possible for the formatting that's used, those initials occur in along the top header of the ballot, and whether or not they're initialed on the front or the back, as long as the ballot is initialed, that is the important thing. And so that was just an item that I saw one day as I was scanning, honestly, like how it came up as I saw it as I was scanning through things looking for something completely unrelated. Yeah, thought we don't do it like that anymore. We don't have, all the multicolored ballots anymore, and so let's update it.
Mr.
Senator
Chair,
Grant.
Senator, I'm sorry, Ms. Freeman, thank you. So I'm good. Thank you, Mr. Chair.
Senator Lucero.
Thank you, Mr. Chair. I am appreciative for Senator Port and Senator Koran because they really get the juices flowing when they ask their questions. So I appreciate coming back to me because Senator Koran's line of questioning there made me think of some stuff. So on page 15, it's speaking about the chain of custody plans. And I read the language here, and I'm seeing the county, I highlighted everywhere that I could briefly find in between line 5 and line 28, the word plan. And I've got at least a dozen here. The county auditor must develop a chain of custody plan, chain of custody procedures, the chain of custody plan. The plan must include, et cetera, it just goes on and on the plan. What I'm thinking of is just putting on my hat of cybersecurity in my role of infrastructure then and protecting against threat actors. We have to have an incident response plan. But there's a consequence to that if we don't have one, or if it's a bad plan with gaps. The consequence of a inadequate incident response plan is that we won't respond sufficiently to an ongoing active threat, and that could result in financial consequences, loss of reputation, things like that, loss of customers. We have to have a vulnerability mitigation plan. How are we going to remediate vulnerabilities that are discovered in the environment? We need to have a compliance plan. If we don't have a compliance plan, we might lose certification with consequences. So with that, I'm just thinking this is a great first step of having a plan. But then when Senator Koran was bringing up the open trunk, Edina area, I think it was, the trunk was open. Let's say there is a plan, a chain of custody plan, but let's say the chain of custody is broken. What is the consequence?
Ms. Freeman.
Thank you, Chair Carlson and Senator Lucero. So I think I will answer the question, but I'm going to back up for just a second and reiterate something that Mr. Stolberger said in testimony too. Chain of custody is already established throughout statute. The requirement for chain of custody to be retained is established throughout statute and throughout rules for, sort of as the ballot is created, all the way through the process, through the contest period, and even, beyond that with the retention requirements. And so these I want to say not these plans necessarily, right? Not these plans in the format that our office might recommend. They don't already exist. But counties and cities already have procedures in place and documentation in place to document that chain of custody that's already happening. And I think in the situation that was mentioned that occurred in 2024, because those procedures are in place, that is how, and I'll also say that it is a chain, right? And so there's not just one, there's multiple checks to it, I guess is what I should say. And so, Hennepin County was able to very quickly in that situation, through their checks, they knew what they were expecting to receive that day from these other absentee locations, from their jurisdictions. And so they were very quickly able to, once those materials were received, say, yes, we have everything that we were expecting to receive. And so I think that's in a situation where there was like an individual error, an individual that didn't follow best practices. There's other parts of the plan and other parts of the process built around it to ensure that we're able to have confidence to either say, yes, we have everything, or if that's not the case, then here's what we would do. And because there's sort of a robust process built around, so it's not just one thing that would cause, sort of the system to fail. So there are multiple checks there to keep it all going. And now I've forgotten your actual question, so I apologize.
Senator Lucero.
Thank you, Mr. Chair. And no, I appreciate that. The having redundancy in systems, having, we call that in cybersecurity, we call that defense in depth. If one control fails, perhaps another will stop it. But even the best laid plans can fail. Even there could be multiple failures in a system. So whether it be that Edina scenario, I'm just throwing that one out because we're familiar with that one. But it could be another one where it's some hypothetical in the future, yet to have happened. What happens when chain of custody is broken? I mean, the ultimate consequence is lost ballots and ballots. I'll even just use the one in Chaska, or is it Chanhassen? Chaska, Chanhassen, that area, where there actually were ballots that are gone now. I mean, that's the ultimate consequence is ballots are missing or are not going to be counted. So whether it be this proposed language and plans or whether it be other areas of statute that were just referenced that also have references to chain of custody, what is the ultimate consequence if multiple steps are broken and we can't establish that it's retained?
Ms. Freeman.
Thank you, Mr. Chair and Senator Lucero. So there's a couple different things that I can think of off the top of my head. There's an individual, an impacted individual could file a 204B.44, an errors and omissions petition to the court. We're in a different section of the bill, not related to this point, but it's later in the bill if you want to look at it, I guess is what I'm saying. And so that's one option. And then the other option is, an eventual election contest, recounts, election contests, and things like that. And then depending on what the action is, there may be other references in statute that prohibit such actions from taking place. So then there may be a gross misdemeanor or a misdemeanor or some other level of a crime too.
That's good, Senator Lucero. Thank you. Senator Swazinski.
Thank you, Ms. Freeman, for being here today. I just have one question on line 720. and I think I know the answer, but could you please, for me, define the difference between designated absentee voting location versus early voting location? I think I know the answer, but I just want that clarification. Thank you, Mr. Chair.
Ms. Freeman.
Thank you, Mr. Chair and Senator. The reference for an absentee location in 203B.08 sub 1 is a location that is open for the full absentee ballot period, so the 46 days. And the early voting location pursuant to subdivision 1A would be just those 18 days prior to Election Day.
Mr. Chair.
Senator Kwasinski.
So would a community be able now, under this change, not have to have two election judges staffing a booth for those 45 days? Now they can just do 18 if they choose to?
Ms. Freeman.
Thank you, Chair and Senator. Yes, I think that's the intention, that if the county has designated them or if the clerk has notified the county that they want to administer, yes, they would have the choice to be open as an in-person election location for the 46 days or the 18 days. Yeah.
Thanks for doing that for our cities and counties.
Thank you, Senator Kwasinski. We have a question from Senator Limmer.
Thank you, Mr. Chair. I have a couple questions that I wanted to ask. Starting on page 15, lines 31. There's a change in a date regarding the appointment list to be recognized. Why are we changing the date earlier? It seems like we have difficulty finding enough people to satisfy it by May. Why are we moving it to March?
Thank you, Senator Carlson, or Chair Carlson, excuse me, and Senator Limmer. What we have heard from local jurisdictions is that receiving the list in the middle of May is about 1 month before their primary absentee ballot board will begin to meet. And so that gives them just a month to hire folks from this list to meet the party balance requirements to start their absentee ballot board work. And so we're happy to continue conversations about what the right date is, but I think the March 1st date would definitely give additional time for that election judge list to be contacted and for local jurisdictions to, manage the scheduling and training of those election judges in preparation for the primary.
Mr. Chair,
Senator
Ms.
Limmer.
Freeman, has it been the observation of the Secretary of State's office that trying to find candidates for election judge are difficult to find by May, let alone March?
Ms. Freeman.
Thank you, Chair and Senator Limmer. I'm not sure exactly what you mean by hard to find. I think that the lists are at times in certain jurisdictions, maybe I'll say it this way, that it is a regular occurrence that jurisdictions will need to solicit other election judge applications beyond the party list. However, I don't know, I can't say whether or not that's because of the timing or because of, just folks think about and hear about the opportunity to serve as election judges in other capacities as well. So not only from if they're involved in a party process or involved in party activities, but I know jurisdictions oftentimes put it in their newsletters and things like that, and they're hearing about it from a variety of sources, and so I can't say whether or not it's because of the timing that those lists are not adequate.
Mr. Chair.
Senator
And
Westlin.
Senator Limmer, I don't know if this is true for the Republican caucus, but I know that when people go to the caucuses in February, generally, people are asked if they want to serve as election judges, and so I do think that information typically is gathered in sufficient time to provide names by March. And again, I think, as Ms. Freeman explained, I think the idea is try to get that information as soon as possible for the county so that if, or whatever the municipality is, so that if they go through that whole list and they still haven't found somebody, that they still have time to do so. But I do know in caucuses, they do tend to gather that information.
Mr. Chair,
Senator
another
Liver.
question I had is on page 18. This is in regards to the election judge's oath. And perhaps this question is best directed to council. On page 18, line 11, there's a reference to statute. Section 211B.075. I'll pause a minute. And then, is there any reference to the person who takes the oath? Is there ever a reference in the oath, according to that statute, that they understand that a violation of the oath could result in prosecution or subject to a penalty, so that they know fully that if they did intentionally create a material false, or whatever it says here in the oath, that if they violate that oath, that they understand that there's a penalty for violating that oath.
Council Stengel.
Mr. Chair and Senator Limmer, 211B.075 is the intimidation and interference with the voting process statute that was enacted in 2023 that provides for intimidation, deceptive practices, and interference with registration or voting. It doesn't specifically talk about any sort of election judge oath or anything like that. So I think what this is doing is pulling in, it's sort of working in reverse. It's pulling in the 211B into the election judge oath statute and not working the other way.
And Mr. Chair
Senator Limmer.
and Ms. Stengel, what would be the penalty for someone that would violate that statute while under oath?
Mr. Chair? Yeah.
Senator Westlin, comment?
So if you go to 211B.075, it literally pulls the language directly from there into the oath because we've added it. And the criminal penalty in that statute is a person who violates this section, which is about intimidation and interference with process, is guilty of a gross misdemeanor. So it's already in statute that you can't do this, and we're just making sure that our election judges are affirming that they are not going to engage in that kind of conduct.
Mr. Chair.
Senator Limmer.
The point I'm getting at is I see the oath here in front of us. I'm just not sure if the person taking the oath understands what criminal penalty might befall them if they violate it. Is there a copy of section 211B.075 in their presence when they take that oath? Do they understand what that statute is? I'm just suggesting that there might be an added line that says, I understand in the event that I violate this oath, I may be subject to criminal penalty. And just so they absolutely know, I think it would be helpful.
Ms. Freeman.
Thank you, Chair Carlson and Senator Limmer. I also just had looked up 204B.26 talks about election judges and violations and penalties. And so any individual who serves as an election judge in violation of any of the provisions in section 204B.19 to 204B.25 is guilty of a misdemeanor. So that is in statute too. To your question about sort of notification of what the broader expectations and sort of penalties might be for an election judge. I can't say exactly what is in our election judge guide, but I do know that in our election judge guide, there is a much more robust section of election judge duties and requirements, and all of that is sort of synthesized there of, you know, if you serve as an election judge, a family member cannot also be on the ballot, like things like that, around the requirements and prohibitions to serve for an election judge, as well as election judge conduct is a section. And so I do think that a part of me thinks that, you know, if we do update this oath, that election judge guide, which is present in every polling, or supposed to be present in every polling location, and is distributed to election judges as they're trained, that might be a good place to put that instead of directly in the oath that they're signing each time. But happy to continue the conversation about that. And I can look up our election judge guide and see exactly what's in there too.
And
Senator Limerick, comment?
thank you for that, Ms. Freeman. One last question I have regarding the processing of ballots. If I can bring your attention to page 12. Put it in context, starting on page 11 at the very bottom of the page. At the end of each day when early voting occurs, the early voting officials must, and then on page 12, remove and secure ballots. Is there a procedure or something that the secure ballots, according to a standard, would be written somewhere? I've looked this over, and it would also apply to lines 7 and 8 of page 12. Is there a procedure or a standard that we could make reference to in relationship to the word remove and secure ballots?
Ms. Freeman.
Thank you, Chair Carlson and Senator Limmer. I don't know off the top of my head the reference of where that would be located, but I do know that in the broader 204B section, 203B section, related to absentee ballots, that there's other instruction in statute as to securing and what that might mean. So I definitely can look into that and see what the right reference might be. And I'll just note we're making these changes and sort of spelling out exactly what the procedure would be for early voting, because it previously had that reference to 203B.121 subdivision 5, and we're now altering things. So 203.121 sub 5 is really specific to the ballot board and processing envelopes. And since early voting gets rid of the envelopes, one of the benefits of it, we wanted to be clear of what the expectation is for that process exclusively. But happy to look at if there's a good place for a reference there to define secure.
Mr. Chair.
Senator Limerick.
Ms. Freeman, you made reference to 203B.121 sub 5. And I see that line is scratched out in this provision. So would that be the appropriate procedure? That would be the reference to secure and remove and secure ballots? And why would it hurt not to have that, some kind of reference there? Why was it removed?
Ms. Freeman.
Thank you, Chair Carlson and Senator Limmer. So if you look actually at the section right before section 10, that's 203B.121 subdivision 5. And there we're clarifying the storage and the counting of absentee ballots based on the procedures followed in subdivision 4, which is section 9. And so because section 11, 203B.30, that's the section of statute that deals exclusively with early voting. And so through that process, ballots aren't inserted into envelopes. They're inserted directly into a ballot tabulator. And so because of the adjustments made in sections 9 and 10, that's why we removed the reference. So while there might be references to the need to secure the ballots, I don't believe what I'm thinking of, but can't remember the exact location of, is in these previous sections.
Thank you.
Thank you, Senator Limmer. We have Senator Barr on the list here, and after. Pardon? Yes, we have another bill to get to, so Senator Barr.
I'll be
we'll,
quick. I'll be quick, Mr. Chair.
Do
So,
final comments after your question.
yeah, real quick, I missed the first couple of minutes of committee. Did we adopt the A4? It has, okay, thank you. So my question is based on the A4. I know Senator Koran already touched on this, and you kind of referenced back the election judge stuff. It's page 5, the bottom of page 5 or middle of page 5. And you referenced back in your answer to current law and things like that, but I just, like on line 523, it's maintains residence in the precinct, and then 24 is maintains residence in the jurisdiction of the ballot board, which would be the county. And then when you get down to 531 to 533, or 532 and 33, the appointing authority may appoint other individuals who may qualify to serve as election judge. But it looks to me, and I'd really, I know our Senator Koran, you said you'd circle back on this, and I'd really appreciate a good hard look, because this sure looks to me like if you don't live in the maintained residence in the jurisdiction or within the county, then you couldn't move, like an Anoka County couldn't be in Hennepin County or vice versa. And if you could just take a look at that and circle back, I'd really appreciate it. That's all I had, Mr. Chair.
Ms. Freeman.
Yeah, thank you, Chair, and Senator Barr. Yeah, I think that the important part is when appointing, when appointing election judges, appointing authority must. So it's detailing what the it's not discussing who could be appointed theoretically, but it is, sorry, on line 5.21, apologies. After the comma, when appointing election judges, an appointing authority must first exhaust, and so we're trying to define in the section, how does an appointing authority exhaust the list of individuals that they're provided? So they're provided the list of folks who live within their jurisdiction, so they need to first exhaust that list, and then they can, in D, 5.31, then they can appoint any other individuals who meet the qualifications to serve as an election judge. So if they if they needed additional election judges to meet the party balance requirements, right, they would either need to be an election judge from a party list or be a judge who swears and affirms their affiliation with a political party through, I'm trying to remember where exactly that is. At the top of 6.1, talks about if someone isn't on the party list, how might they be, affiliate themselves with a political party and meet the party affiliation or party balance requirement there.
Senator Barr.
Quick follow-up. So there's actually multiple lists then, so you could apply directly through, say, the county or the precinct and the party? So there'd be like a party list and a local list that they'd have to exhaust? Or is it the local exhaust? I just kind of trying to follow this. I'm sorry if I'm being redundant here.
Ms. Freeman.
Thank you, Chair and Senator Barr. Yeah, so how the process runs right now is that that jurisdictions must first exhaust the list of folks from the parties. So just from the parties, and so within their jurisdiction, that's the first step. Once that is done, then they could move on to other folks who have indicated their interest in serving as election judges. So that might be applying. Folks have different application processes, right? So yes, then that would be folks who have applied either to the county or to the city or township who is holding that ballot board. And then if folks meet the requirements to serve as an election judge, then they can be appointed additionally. And if they're in need of additional folks to meet the party balance requirements, that's where at the top of page 6, that process comes in of how someone who's not coming from those lists, oftentimes people might I think we all know people who don't don't attend a caucus meeting maybe, or aren't super involved in their local party unit, but they strongly affiliate with a party, right? And so it's for those other folks that might not come in through that list, yeah.
Thank you.
Final comments, Senator Westlin, and I need to say that we're at 4:30 now, and so we have to be really prompt on finishing our next bill, or we might have to come back tomorrow.
Thank you, Mr.
Senator
Chair. I
Wesson.
will be very prompt and just say thank you for the questions and the discussion. It's a long bill, it's a technical bill, and certainly appreciate the questions and the opportunity for Ms. Freeman and to some degree myself to help answer questions. And I believe, Mr. Chair, it would be appropriate to move the bill to pass as amended and recommended to pass to judiciary.
Yes, Senator Westlin moves to pass Senate File 2384 as amended and forward it to the Judiciary and Public Safety Committee. All those in favor say aye.
Aye.
All opposed, nay. The motion is passed, and Senator Westlin, you're on your way to the Judiciary Committee. Next bill is Senator Koran with Senate File 2232. And I have to point out that this is a bipartisan bill. And thank you, Senator Koran. If you just identify your voice for the record and continue with your presentation.
Thank you, Mr. Chair. State Senator Mark Koran, happy to present Senate File 2232, County Elections Administrator Bill. And so we'll go through this fairly quickly. I'll just give you a quick highlight. So the changes requested by the county after all the changes in the last election season, just as we just had a conversation about those areas that need to be fixed or modified and adjusted to make sure it works well. Counties have done a good job at assembling a variety of requirements that they believe will make it easier to run our elections. So at the high levels, it allows electronic polling place rosters to combine voter lists when precincts are combined. Also moves the deadline to submit an absentee ballot application, not in person, to a week before the election instead of the day before the election. Removes party balance requirement on ballot boards for county elections, not in conjunction with state elections. Moves filing periods for local elections up to 2 weeks, and disclosure requirement for sample ballots. And so that's kind of just the high level. And then we have, I believe, Michael, Mr. Stolberger is available, and he's going to walk through the details of the rest of the requirements. He did an excellent job at assembling them. And so, Mr. Chair, off to Mr. Stolberger.
Thank you, Senator Koran. And Mr. Stolberger, please identify yourself for the record, and you are going to walk through the bill as it is being presented.
Good afternoon, Mr. Chair. Again, Michael Stolberger, Director of Property and Environmental Resources, Blue Earth County, representing MACO, the Minnesota Association of County Officials. We do echo what Senator Koran said there, that we do have several items being presented here in what we're considering more of a technical bill to address some of the inefficiencies or some administrative hurdles that we recognized in the last couple of elections. And these are also items that we think might improve some understanding and transparency for voters. We've worked very closely with the Secretary of State's office on this bill, and we also have worked with the Association of Minnesota Counties. They are supportive of the bill as presented. I will try to be respectful of time with the committee's time here, but there are several very technical items here, and I will run through them quickly. But please feel free to ask questions after my testimony if there's anything that I need to provide more detail on. Sections 1 and Section 11 do allow for combined polling places to share electronic rosters. When a polling place is officially combined, they can share resources to be more efficient, such as election judges. This change would allow them to also share those electronic rosters so that election judges don't have to try to manage two sets of devices. Voters don't get confused by why one device is being used for certain voters to check them in. And it also saves costs and time in terms of preparing those rosters and purchasing them for use. Sections 2, 6, and 7 change the date by which absentee ballot applications must be received by elections administrators, and it also requires more complete online applications. These are some very important changes for the administration of the absentee voting process. And really what we're getting at here is we want to make sure that we have enough time to process those absentee ballot applications so that the voter can legitimately receive a ballot in the mail and have time to return it to the elections office to be counted. And so we do want to point out that this applies to online applications and mail-in or drop-off applications. It does not apply to voters who are located in hospitals or healthcare facilities. It doesn't apply to any of our emergency response providers who have some provisions in law. It doesn't apply to our military and overseas voters. But what it does is it establishes that deadline 7 days before the election for ballots to be submitted online or mailed in or dropped off. And what that really does is allows us to meet the time requirements that we now recognize with the Postal Service. We look at that process from receipt, processing, mailing out a ballot, giving the voter time to vote the ballot in time for the post office to mail that back, get that back to us as being about 6 days. So we want to make sure that there's time for us to work with that voter in order to resolve any issues with that absentee process. What it also allows us to do in these instances is make sure that the voter clearly understands what options they have for voting. And so if a voter tries to request a ballot online or via the mail inside that window, we would be required to communicate with them how they can vote in person, how they can have somebody pick up a ballot if they meet certain eligibility requirements, or vote on election day. As mentioned, as part of that election season, we want them to understand all of those processes. The other really important change there is that if an individual is requesting a ballot online, we would like to require that they provide not only the last four of their social security number, but also their driver's license or their state ID number, so that we have two ways to verify their record to make sure that it is an eligible voter, but also to have multiple ways to verify that that ballot is being returned by that voter so that we have every opportunity to accept it. We are unfortunately have to reject many ballots that come back from an online application because the voter uses the wrong identifying field and we have no signature to match. So that's a really critical change to make sure that voters who are voting can actually have their ballots be counted. Section 3 allows absentee ballots to be handed off from 2 election judges to 2 employees of a healthcare facility or hospital during what's called healthcare facility outreach voting. This is only allowed in certain circumstances when a voter may be in isolation or quarantine, or there may be safety concerns for having election judges interact with those voters. Our election judges actually requested this change for their safety as well, and so it would only be allowed if a healthcare professional at that facility says, sorry, election judges, you should not be interacting with this voter for health reasons. And in that instance, 2 healthcare facility voters would then become the courier. They would essentially bring the ballot into that voter and then return it promptly to the election judges for safekeeping and processing. Sections 14 and 13 allow the county boards of commissioners to appoint election judges to their ballot board for a nonpartisan county special election, regardless of party affiliation. And so cities and towns currently have this provision, as do schools, where if they have a standalone special election, they can use ballot board members of any party affiliation, or essentially there's no party affiliation designation. We'd like to see that same provision allowed only for those special elections of like a county board member, county sheriff, or county attorney. This would never apply if there's a state election also being held at that same time, then party balance of election judges is required. Section 5 would allow us to determine between an arrangement with a city and the county what is the best way to process at the UOCAVA ballots. UOCAVA ballots are for our overseas and military voters, and under the intricacies of current law, the county must mail those ballots out and must receive those ballots back. However, if a city has designated authority to be a ballot board, the county then has to courier those ballots to that city. So this one came out of our friends in St. Louis County, actually, where they are couriering ballots multiple hours to cities on election day, because they're a UOCAVA ballot that was received on election day, delaying results and creating inefficiencies and concerns potentially with chain of custody. So we would like cities and towns, if they have delegated authority, to be able to say, hey, county, you go ahead and count and process those ballots following the exact same rules so that we can be more efficient in our work. Section 6 and 7 have already been discussed. They're that absentee ballot application changes. Sections 8, 9, 14, and 16 propose some efficiencies with the candidate filing process or the affidavit process. One of the changes would require a phonetic spelling or explanation for the pronunciation of a candidate's name, or a certification from that candidate saying that we can use our ballot programming technology's pronunciation for that name. They all have text-to-speech built into our programming. What that does is it ensures that we won't have errors and we don't have to do rework when it comes to programming the names for our voters who are using our assisted voting devices, and it streamlines our tracking down of how to pronounce candidate names. The other changes in the sections that I described would require a candidate, when a candidate affidavit is received at a city, town, or school district level, that they provide those within 1 business day or immediately following the close of the filing period to the county. This again would be based on an agreement between the city and the county, or the township and the county. And what we're trying to do there is make sure that we can process those quickly into the statewide systems so that we can catch errors, look for any issues, and start producing ballots to be used for elections as quickly as possible and as error-free as possible. Section 10. Section 10 is a very technical change that will align the date that write-in candidates must file to have their votes counted with the date that our ballot boards can actually start processing those ballots. Under current law, our ballot boards can start working with those ballots on 18 days before the election, essentially. However, we don't know which write-ins to be looking for until 7 days before the election, and so we would like to align those days so that our ballot boards don't have to do redundant work there in looking for write-in votes. Section 11 was related to electronic rosters, so we've already talked about that. Section 12 allows for flexibility in determining the delivery of election supplies from the county auditor to the municipal clerk. Under current law, counties are required to turn over materials 4 days before the election, even if cities aren't ready to receive those, even if townships don't have the space available for that, we're required to meet that. We'd like to change that to provide flexibility to deliver up to the day before the election, to give us better management of chain of custody, security of elections equipment, but also to make sure that we can find a schedule that works best for everybody involved during those busy days. We know that we'll need to continue conversation with our cities and towns to figure out the exact dates for those. Sections 13, sections 14 have already been discussed. Sections 15, 17, and 19 do modify that late candidate filing period for our cities, towns, school districts, and hospital districts. And this is a change that moves that late filing period back 14 days so that it doesn't overlap with the state primary election. Under the current calendaring system, we almost always have a conflict where our city clerks, our township clerks, our county officials have to be trying to receive candidate filings on primary election day or the days leading up to it, creating for a requirement to be in 2 places at one time, which we know can't happen. And so what we're doing is we're looking at moving that back so that we build some time into that process to better manage that process and also reduce the number of errors and potential issues that would be created just in trying to spread ourselves too thin. That again only applies to those local non-primary eligibility contests. So city council members, school board members, in many instances, township officials. Section 16, Section 17 have already been discussed. And now Section 18 is one of the other provisions in our bill that would lead to some pretty impactful changes for elections administration. And what this does is this requires how non-government third parties can distribute absentee ballot applications and sample ballots. And this change is most requested by our county elections administrators across the state. We heard this repeatedly as we talked about elections and debriefed our activities and our performance after the 2024 election. What we're essentially asking for is that when a person or an entity who is not an employee of a unit of government sends out a sample ballot or sends out an absentee ballot application, that they include a statement that says that it is not official, and for instances of the ballot that it cannot be cast. We also want that sort of statement on envelopes. And what this will do, this will help reduce unnecessary confusion and, to be frank, and many times anger from voters who are wondering why they continue to get absentee ballot applications, or what we hear all the time is, why do you keep mailing me ballots? I don't want to be voting these, when they're actually a sample ballot. Another change in this section is that if an absentee ballot application is sent out, it must be blank. We've heard, as elections administrators, repeatedly across the state, frustration from voters who receive pre-filled applications that have outdated and incorrect information on it. And while that information is public and it is available, when it is not right, we have voters who are unhappy or who have concerns about the integrity of the election, and we want to prohibit that and require voters to completely fill out that application on their own, or have somebody assist them in filling out that application, which is already allowed under current law. We have numerous examples that we'll save going into detail on now of married names not being updated, deceased voters receiving those applications, all those things that we would like to prohibit by not having them pre-printed or pre-filled. And then section 19, we've already covered. That last section on our bill is related to that late candidate filing period. So I know I went through that very quickly. I do apologize for that, but I did want to make sure I left time for questions and additional testimony. But we do want to end by saying thank you to Senator Koran, to all of the authors of this bill. It is a bipartisan bill, as was mentioned. It is an opportunity for us to discuss some abilities and some opportunities to improve election administration. MACO is always looking to make sure that we reduce administrative burden, enhance voter understanding and transparency. And we really pride ourselves on ensuring that every voter who is eligible and who wishes to vote is able to do so in elections that free, fair, secure, and accurate. And so this bill helps us move in that direction even farther. So I'll conclude my testimony, but I'll remain for questions. Thank you.
Thank you, Mr. Stahlberger, and thank you, Senator Koran, for bringing this bill forward. Do we have, Ms. Freeman, would you like to add your comments? Ms. Freeman.
Thank you, Chair Carlson, and thank you, Senator Koran, for bringing this bill today. Nicole Freeman, the Office of the Secretary of State. I am here today in support of Senate File 2232. We really appreciate the work of MACO in putting this bill together and appreciate the partnership working with them on this bill language as well. As Mr. Stahlberger noted, the bill really does include a lot of technical items and other changes that will improve the efficiency and the administration of our elections, and we're happy to see them. I think the only piece I want to note that we are still in conversation on is around the deadline for submitting absentee applications online and by mail. OSS's preference would be that the deadline be the Friday before Election Day. And so we're happy to continue those conversations as time goes on. Thank you very much.
Thanks, Nicole.
Yeah, thanks.
Senator Koran, any comments, further comments?
No, we appreciate the support of the Secretary of State, and we'll continue to work on all of the issues that arise between now and the time we decide what's in what bills and we get to the floor. So, but I think Mr. Stahlberger said it perfectly. All of it's with the goal of making sure it's fair, secure, and accurate, all of our elections. So.
Yes. Thank you. Any comments from the members? Questions from the members? Well, thank you. This bill is, oh, Senator Barr. No?
They didn't have Senator Port.
Did we have anyone that wanted to ask questions? No? Okay. So we'll be laying this one over for possible inclusion in the omnibus bill. There are a few things that still need to be just fine-tuned a bit. And so, oh, I'm sorry, Senator Port.
Thank you, Mr. Chair. I just have one piece to point out. There is a portion in here where it talks about the deadline for absentee ballots. applications to be accepted, and that it's pushed out to 1 week before Election Day, rather than the current standard of the day before Election Day. And as you continue to have these conversations, I would love to be engaged with that. That seems pretty far ahead, and concerns me a little bit. So that would be one piece I'd just like to remain in conversation about.
I noted it, Mr. Chair.
Senator
I
Grant.
noted it, Senator Port, and we'll continue to work on it between the Secretary of State and Mr. Stahlberger and myself, so.
Thank you.
Thank you. And Senator Grant, do you have any final comments?
No, I think I appreciate Senator Westlin wearing everybody out, and so we got through the bill in a timely manner. So thank you for everyone's support. Thank you.
Thank you very much. And so the Senate file, where are we? Senate File 2232 is laid over for possible inclusion. And the meeting is adjourned.